Good morning, this is your Kelso Report for December 16th, Friday. I'm your host, Clark Kelso. We begin with international law and arbitration. In Ministry of Defense of Iran versus Cubic Defense Systems, the Ninth Circuit held, consistent with the position taken by the United States government in an amicus brief, that the public policy of the United States was not violated by enforcement of an arbitral award in favor of the Ministry of Defense of Iran, pursuant to the Convention on the Recognition and Enforcement of Foreign Arbitral Awards. The Court's holding recognizes that even though we have imposed certain sanctions against Iran, the United States has a very strong interest in upholding international arbitration awards, and that the public policy exception to enforcement should apply only when enforcement would violate our most basic notions of morality and justice, a standard that wasn't met in what basically was a breach of contract action. The Court also held that a district court has discretion to award prejudgment interest and attorney's fees in an action to confirm an arbitration award under the Convention. Our next case is also an arbitration case, this time domestic, in Sky Sports versus Hogan. The Second District held that the defendant did not waive its right to file a motion to compel arbitration when the named class representative did not agree to an arbitration clause with the defendant employer, but most members of the class of employees did sign an arbitration clause with the defendant. The defendant filed its motion to compel arbitration after the class certification had been granted, and the Second District held that was the right time to file the motion. The Court remanded to the trial court for consideration on the merits of whether the motion to compel arbitration should be granted or denied. Next, in the area of civil procedure, in Provost versus Regents of the University of California, the Fourth District affirmed the trial court's decision to enforce a stipulation for settlement that had been reached after mediation proceedings between the plaintiff and the defendant. The court rejected a variety of mostly technical challenges to the stipulation raised by the plaintiff, such as that a signature by the Board of Regents as authorized attorney representative was somehow not sufficient to bind the board. The plaintiff also alleged that the stipulation did not contain all material terms, was obtained by duress and coercion, and by fraudulent concealment, and was unenforceable because of rules regarding mediation confidentiality. And these were all insignificant contentions, which the court readily brushed away. You stipulate to a settlement, the court's going to enforce it. Our next case is in the area of criminal sentencing, very technical issue, in People versus Murillo, where the Fourth District held that separate and consecutive sentences were mandated for a deadly weapon enhancement and a great bodily injury enhancement. The defendant argued that the one-year sentence enhancement for the deadly weapons should have been stayed by Section 654 of the Penal Code. But the court rejected this argument, concluding that Section 1170.1 of the Penal Code mandates that these two enhancements be treated as separate and consecutive sentences, notwithstanding Section 654. Next, an interesting search and seizure case. In People versus French, the defendant pled guilty to transportation of psychedelic mushrooms after his motion to suppress evidence gathered at his home pursuant to a search warrant was denied. He argued on appeal that the warrant was improperly issued because the affidavit in support contained allegations based entirely upon 3 informants, none of whom were reliable. Although the police corroborated certain incidental details about the suspect, none of the information that was corroborated actually pertained to the alleged criminal activity. In these circumstances, and absent any other information, the First District held that the warrant should not have been issued. Now, the court nevertheless affirmed the conviction under the good faith exception to the exclusionary rule because the officers could reasonably have believed, based on broad language and certain prior court opinions, that multiple unreliable informants can corroborate each other in support of a request for a search warrant. So apparently 0 plus 0 can equal 1, according to these prior cases. Well, not according to yesterday's case. Our next case involves an issue in community property and a long-fought issue involving a will and distribution of property from a trust. In Patrick versus Alasser, the 4th District held that a surviving spouse was entitled to her share of the increase in value of stock that the deceased spouse owned prior to their marriage, because the increase in value was attributable in part to the efforts of the deceased spouse. The court also held, however, that the surviving spouse was not entitled to the stock itself, since the stock was separate property at the time of their marriage. So the stock is separate, but the increase in value was community property. Next, the area of limitations. In Aiuto versus City and County of San Francisco, the 1st District held that a city ordinance which established a below-market rate condominium conversion program was an ordinance that, quote, concerned a subdivision, close quote, under the State Subdivision Map Act. And therefore, any challenges to that ordinance had to be brought within 90 days of the enactment of the ordinance. Since plaintiff's claims were brought more than 5 months after the enactment of the ordinance, they were time-barred. And the appellate court reversed the Superior Court's order granting a preliminary injunction. Well, our next case is a remedies case. Bardasian versus Santa Clara Partners Mortgage Corporation. Excuse me, where the 3rd District held that it was error for the Superior Court to have imposed upon the plaintiffs the posting of a preliminary injunction bond when the Superior Court, in ruling on a request for the preliminary injunction, had actually ruled on the merits and, as interpreted by the 3rd District, and contrary to what the Superior Court said it was doing, had actually entered a permanent injunction. Now, the plaintiffs in this case were homeowners who were more than $100,000 behind on their mortgage. The bank was ready to foreclose, but the homeowners asked for a preliminary injunction on the ground that the bank had failed to comply with Section 2923.5 of the Civil Code, which requires a lender to first contact a borrower to explore options to avoid foreclosure. The parties filed competing declarations, and based solely on the declarations, the Superior Court found in favor of the plaintiffs and granted the request for a preliminary injunction. But the court also imposed a preliminary injunction bond on the plaintiffs, as well as a requirement that the plaintiffs pay $500 per month toward the mortgage, noting the inequity that the plaintiffs were living in the house essentially rent-free. Well, the 3rd District's reinterpretation of what the Superior Court did, now it may be a sensible resolution of the problem, but it frankly seems to me that the 3rd District reached pretty far out to reframe the Superior Court's actions as though the court actually reached the merits and had granted a permanent injunction. If nothing else, the fact that the Superior Court imposed a preliminary injunction bond would suggest that the Superior Court itself believed it was imposing only a preliminary injunction bond. And moreover, it's actually improper for a trial court or an appellate court to reach the merits when considering just a motion for a preliminary injunction. You know, there's a little something known as due process that should prevent a trial court from deciding the merits prior to a full trial. So while the 3rd District's heart may be in the right place to give the plaintiffs relief from the injunction bond, the facts and the law really don't seem to support the 3rd District's decision. And I think we may see the 3rd District either withdraw its opinion after motion for rehearing, or we may see some action by the Supreme Court. At a minimum, a depublication order would seem to be appropriate in this case. And that's it for today's Kelso Report. Have a great day in the law.